So we said that at the beginning of the chapter, we have the Trayvon Martin shooting and Michael Brown, right? Which occurred in Ferguson. What do those have in common? There's a ton of stuff that they have in common. What are some of the things?
What do they think they have in common?
Yeah. Or, I mean, what?
They were killed.
They were killed. They were, yeah, two deaths. It resulted in 2 deaths.
2 young people killed. 2 black young people killed.
Yeah, both of them. Yeah, 2 young people, 2 black young people. Who has a quick thumbnail sketch of? We'll go with Michael Brown. Who remembers the Michael Brown shooting? And can you give us just a quick rundown of what happened? Start with a police officer stopping Michael Brown.
Apparently, Michael Brown was there, so the police officer.
Oh, okay. In general, what resulted in Michael Brown's death?
A tussle with the police officer.
There you go. Obviously controversial. Obviously, there's 2 sides. There's a lot of different aspects to it. What about the Trayvon Martin shooting? Trayvon Martin was again stopped. I'm sorry.
Killed by a citizen.
Right, by a citizen, by George Zimmerman. Yes, thank you. Again, similar, stopped. There was a tussle and resulted in a shooting and a death. Did either one of the shooters go to jail?
Zimmerman went for a minute. Yeah, he didn't get charged like he should have, but
Later on. Initially,
but,
no.
No, initially, no.
Right. Why?
The defenses that were used.
Was there any doubt, initially or now, is there any doubt that the police officer shot Michael Brown?
No.
Is that in question?
No.
Not that I know.
No.
Not that I've heard. And Mr. Zimmerman, George Zimmerman, is there any doubt regarding the story that Zimmerman shot Trayvon Martin? Right.
There's no doubt.
So there's no doubt at all. So that kind of takes away some of the defenses, right? So there are some defenses where, let me see, I'm trying to think of my own experiences. Okay. I was trying to think of a complaint. So at some point during my career, I had more than one citizen complaint. And the vast majority of citizen complaints are usually shown to be unfounded. Some of the times, citizen complaints against police officers are in retribution. Sometimes they're true. Sometimes the police officer acted wrong. But statistics show that there are more complaints proven untrue than true against police officers. So I'll tell you, I had one against me, wherein the young lady came into the police station. To be honest, I don't remember what the initial interaction was, but at some point during the conversation, she expressed a desire to speak to a supervisor. And that supervisor ended up taking a complaint from the citizen against me. And the nature of that complaint was that I had stolen her ovaries.
Oh, God. That's not real. Come on now.
It is. So
Dr. Bell.
I stand here before you today and assure you that I did not. Am I defending myself right now?
Yeah.
In a way, sure. What is the difference between what I just said, that story, and the George Zimmerman, what George Zimmerman said, and to be honest, I'm drawing a blank on the officer's name in Ferguson, but the police officer in Ferguson who shot Michael Brown. What is the difference between what they said about their actions and what I just said about my story? Because we both were accused of wrong, right? The police officer was accused of wrongdoing. George Zimmerman was accused of wrongdoing, and in this case, would it be illegal, immoral, unethical, and against policy for me to steal ovaries? If I did that, then I would be in the wrong. So all three of us were accused of wrongdoing. What's the difference between what the police officer said and George Zimmerman said and what I said?
They have legal defenses or facts. They have facts.
So we talked, exactly, so we talked about, they came out, what did they say they did? Was there any question about what they said
No,
they did?
they didn't shoot it.
They 100%, yes, I did it, but, right? Can we say that I did it, but? What about me? When she accused me of stealing those ovaries, or her ovaries, did I say I did it, but?
No.
What did I say?
Automatically denied.
I didn't do it. And there were several ways to prove that I didn't do it. But that's the difference in types of defenses. That's what, so if you have to say I did it, but, then you are justifying your action. You're saying, I'm not legally guilty of this crime because I'm not saying I didn't do it.
Right.
But what I'm saying is, I did it, but I'm justified in my actions. And that's how you start to break down justification. I'm not going to get too deep into that ovary conversation to find out what kind of justification one would have. Well, at least in my agency, every citizen complaint is mandated to be taken and investigated. Now, the length of that investigation, I'm sure, I was very young when that happened. I probably had 2 years on it. So close to 2 decades ago. Now, the investigation behind the scenes, I don't imagine took very long, but many other complaints are far more lengthy, far more warranted. Sometimes people just don't act right. And why do you think every citizen complaint should be taken, or is taken? I don't know if it should be, but why do you think every citizen complaint is taken? I'm sorry? Sure, yeah. I mean, because who's to say, at what point do you draw that line, right? It's easy to draw the line with the ovaries, right? In the section we talk about extremes. It's easy to come over here and say, that's absolutely ludicrous. We're not going to take that. And it's so easy to come over here with a very legitimate complaint of police misconduct or even the Ferguson shooting. I don't know, but I imagine there was a good chance that somebody initiated a citizen complaint about that shooting. And is that worth taking? That kind of controversial shooting, is that worth taking? Sure. We take complaints because we need to investigate them. But that you bring up a good point, because citizens need to feel vindicated and need to feel cared about, right? But what about statistics? What if police stations or police officers, police supervisors only took complaints that looked like they were legit?
Discrimination. That can be discrimination.
Sure, depending on how you judge legit. What does that do? How does that affect our rate of guilt versus innocence? So as a supervisor, as a police chief, police chief of Bel PD, if I decide I'm only taking complaints where it looks like my officer did something wrong, what is that percentage of guilty findings going to look like, as opposed to if I take every complaint, and then when the police commission or the city council asks, well, what percentage of your officers, when people complain, what percentage are doing wrong? And if I take every complaint, including the ridiculous ones, the ones that I know that they're just sour grapes because the citizen didn't like being arrested, so they made up a story, and the legitimate complaints, and I find 10% of those to be true. 10% of all those complaints end up being true. But then I only take the ones, or my counterpart, another city, only takes the ones where they look like they're guilty. Like, I don't, ovaries, I don't care about that. Sour grapes, I know you're lying. I'm not taking that complaint. I'm only taking the ones where it looks like they did it. And then what percentage of those are going to end up being guilty?
100%.
Almost 100%, right? So a city council comes to you and says, hey, what percentage of your officers, when you investigate your officers, what percentage of them are engaged in wrongdoing? And you've got 90 to 100% of your complaints coming back sustained. How dirty does your department look? Absolutely, right? Looks like your entire department is engaged in misconduct because nearly 100% of those complaints are being sustained. So why not take every single complaint so you can show exactly how the true picture of what's going on? If you screen those complaints, you're not giving the citizens, and again, we care about the citizens, that's who we're serving. We want to give the citizens a full picture of exactly what's going on when it comes to investigating misconduct. We don't want to hide anything. So we talked about legal and factual defenses. So somebody touched on factual. Ooh, somebody over here, who was that?
Factual is like kind of an alibi or, you know,
So alibis. So the lady who said that I stole her ovaries the night before. I was working at 6 a.m. and she said I stole them at 2. Came in and said I stole them at 2 a.m. the evening, a few hours earlier. And I got to work at 6. Do you think I could prove where I was at 2 a.m.? Probably, right? I mean, maybe I was at home, asleep. Maybe I had folks at home that saw me. Maybe I was up in the club and there's a camera. I don't know. Maybe I was somewhere. Maybe I went to an ATM. But I could prove that where she said it happened, I wasn't even there. Not only did I not do it, I wasn't even there. And that's where alibis come in. Alibis are being able to prove factually that you weren't even there. And that's one of our factual defenses. We diverge when it comes to defending ourselves between factual and legal defenses. You can see that in the book on page 142. When we have a factual defense, we're saying, I didn't do it either because I wasn't there, or I have some sort of evidence that I can show that proves that these allegations are completely unbased. But but legal defenses. What do we know about legal defenses? They're different. We talked about it a little bit when it came to Zimmerman and Michael Brown. So there's a justification there. Yeah.
I did it, but
Yeah, that's legal. What about this? In general, who knows what a statute of limitations is? Statute of limitations, not statute.
That's when time runs out that you can't charge a person.
Exactly. Why do we have that?
Why? I'm not quite sure.
We don't want things holding over their head forever.
Yeah.
It's unfortunate sometimes. So when I was investigating sexual assaults, it was unfortunate. A lot of bad things happen to children. I don't want to say a lot, but bad things happen to children. And sometimes those bad things don't get talked about for a long, long time. And unfortunately, there's a statute of limitations that says if those things aren't discussed and brought up to the police in a certain time, my hands are tied. I was still investigated. I was still presented to the district attorney for filing. However, I knew what the result was going to be. The district attorney is going to look at that and they may say, wow, that's a great investigation. You have all the evidence. Wow, that guy 100% did it. No filing. Because that happened 20 years ago.
Do the statute of limitations differ in different states?
Yeah, here there is a statute of limitations on sexual abuse.
Okay,
And in California, they recently changed it.
they need to change that.
So, in general, this is just a general rule. The statute of limitations is the length of exposure for that crime. So, if you can get 1 year in county jail for punching somebody in the face, then in general, the statute of limitations would be about a year. If you can get 10 years for shooting at somebody and missing, then that gives whoever's going to either report it or investigate it 10 years. Otherwise, the statute. What about murder? What's the exposure for murder?
Is there none?
What can you get in jail for murder if you murder somebody? Like you look like you might be thinking about committing murder. You got that look in your eye. If you were to do it today, how long do you think you could go to jail for, or could go to jail for? Life. So, which is the other way of saying forever. So what is the statute of limitations in general for murder? Right, so there isn't one. Whatever the exposure is in general, you don't need to know that for the test. So, if I think did we show a video in here about that showed that had the statute of limitations on a homicide? I don't think it was this class. So there was a domestic violence homicide. We talked about double jeopardy. And there was a domestic violence homicide wherein the gentleman was tried and found not guilty for killing his girlfriend or fiance.
Yeah, we did watch.
We did watch that. Okay. Do you remember then after the trial, sometime after the trial, some additional evidence was found, I think in his house or in his ex-girlfriend's house. They found pictures, maybe some body, some physical evidence, some body, blood, or something really, really incriminating. Where it's like, oh, okay, well, there's pictures of him killing and torturing her. I think that's what it was. Pictures of him raping and torturing her. He'd already been found innocent, so he couldn't. In theory, he couldn't be tried again for that crime. But we learned he could be tried for other things like lying.
Perjury,
Yeah, I think, and if they only tried him for murder, they could be tried again for the rapes, things like that. However, what did he do once all that evidence came out? Remember what he did? He said he did it. He came out. He had a press conference. He said, "Yep, I did it." I don't remember exactly what he said. What else he said, but in doing so, in having this conversation with the press, he flat out admitted it. What do you think about the statute of limitations? What if instead of a double jeopardy case, that had been a statute of limitations case?
he would have went to jail.
And he waited until, well, it was a murder, but we'll throw away the murder because that has no statute. But rape, I think 30-ish years, I think, is maybe the longest I've ever seen. That's usually multiple. So I just want to be super conservative in this example. Let's say he waited 30 years and the statute 100% expired. Just can't be filed on for that case. And then he had that press conference on the 31st year and said, "Yeah, I did it. Raped, tortured her. Didn't say he killed her because there's no statute for murder." What's going to be the result?
Conspiracy.
Well, we can find other crimes, but conspiracy, I doubt it's going to have a worse exposure than the actual. We have to throw the murder out of this. For this
All
example.
together, okay.
Is it going to be the same as a double jeopardy? Could you just come out and say it with no repercussion or very little repercussion? Yeah. And law, that's the way the law reads. I mean, you can't be held criminally liable after that statute closes. So, if you go to trial for some reason, or even if you're avoiding trial and you're talking to your attorney or the police, and you say, "Yeah, I did it," or your attorney is arguing the statute. The crime is alleged to have occurred 6 months ago on a 1-year statute, and your attorney goes and says, "Yeah, my client did it, but he didn't do it 6 months ago. He did it 18 months ago. And I have proof to show that this crime did occur." We're not saying it didn't occur. Whatever, punch him in the face. This crime did occur. You punched him in the face 18 months ago, and I can prove it. Is that a legal or a factual defense? Legal or factual?
Somebody said factual.
Factual?
Somebody said over.
Okay. So factual would be, I didn't do it. And here are the facts to prove I didn't do it. Legal is more of a loophole, or we're using the logbook to show that we're innocent. I did it, but.
I did it, but.
So in this case, it would be an I did it, but, right? I'm saying, yes, I punched him in the face, or whatever, whoever was my example. I punched him in the face, but it happened 18 months ago. George Zimmerman, I shot Trayvon Martin, but he was banging my head on the sidewalk and I was gonna die. The officer in Ferguson, I shot Michael Brown, but he reached for my gun, and if he had gotten it, he would have killed me. Those are legal defenses. I didn't steal her ovaries is a factual, I'm sorry, yes, a factual defense. I actually did not do it. Or I couldn't have broken into that house because I was at home and my family saw me. Or, you said that I did this while I was at work. I was in front of a classroom full of 20 students. They all know I wasn't. I couldn't have done whatever you said I was doing. I was here in class. I'm on camera doing it. Factual. It's factual that I did not do that. But if you say I did it, but legal.
Not that it's always going, or that legal defense is always going to be justified.
No, it's just a defense, right? Sometimes you just throw stuff up against the wall and see if it sticks. So in our criminal justice system, do we need to defend ourselves? Who has the burden of proof?
The prosecutor.
Right, prosecutor does. So do I need to, if I'm accused of a crime, do I need to say anything?
No.
One would say I have the right to remain silent.
Prove it.
So that's exactly right. Prove it. So it's the prosecutor's job, the people. It's their job to prove the crime. And what do they need to prove? What do we call that recipe of a crime? The corpus delicti, the body of a crime, the elements of a crime. And if they don't prove one of those pieces of the recipe, then we have they can't be found guilty in theory, right? Do I have an option of defending myself? Sure. How could I go about doing that? We use the ridiculous one about the ovaries. How could I have gone about defending myself on that? If I had gone to trial, is it a crime to steal organs?
Yeah.
Yeah, okay, so we have a criminal offense. If I had gone to trial, how could I defend myself? What defenses could I have used?
I was at home, I was at work.
My alibi is one, yeah. I never met this person. This is the first time we've ever spoken.
In that area at all. Cameras.
I don't have any ovaries on me. There's nothing in my, there's nothing in my pockets, things like that. Evidence. If I start going on the offense and I start saying, here's all the reasons why I'm not guilty. We call that an affirmative defense. And affirmative defenses can be handled in a couple different ways by the prosecution. So remember, if I say nothing and the prosecution says nothing, what's the result of that trial?
Nothing.
Not guilty, right? If I say nothing and these are our elements of the crime. We have 4 elements of the crime. If I sit at the defense table and I say nothing and they prove this one, and this one, and then they arrest. And I say nothing, and they say, okay, defense, it's your turn. I say, I got nothing to say. What's the result of that trial? Not guilty. However, if I do say something, we handle it a couple different ways by the prosecution, depending on the jurisdiction. So, I should have left it here. Four elements. They proved this one, and this, or they showed evidence for all 4. What kind of shape am I in right now? It's my turn to decide whether or not I want to talk or not. As a defense, my attorney will speak for me. If they've shown evidence for all 4 of the elements of that crime, what kind of shape am I in? Bad shape, right? Bad mojo right now. So maybe I want to have an affirmative defense because if I say nothing, they've shown evidence for all 4 elements of the crime. Things aren't looking great for me. So I say, there's 3 reasons why I couldn't have done it. Regardless of the reasons, it could be alibi, justification, whatever. This is just theoretical. There's 3 reasons why I couldn't have done it. Depending on the jurisdiction, these reasons, whose job is it to prove these reasons is what's dependent on the jurisdiction. Sometimes It is 100%. If I say something in my own defense, then it's my job to prove why that's true. I can't just be all crazy and say anything willy-nilly. I have to say it and then give evidence about it. And then say it and then give evidence about it, and then say it and give evidence about it. And the jury will listen to those three. Other times, other jurisdictions, I can say whatever I want. These are the three reasons why I didn't do it. Boom, I'm done. And it's incumbent upon the prosecutor to come back and say, well, he said these are the three reasons, but let me tell you why those are correct. Because this couldn't have happened. He said it did. He was actually there, and he went to night school and took ovary removal 101. So the prosecutor has now disproven all three of my defenses, my affirmative defenses. So depending on the jurisdiction, that's how these are handled. Either it's incumbent upon the defense to prove their rationale, their defenses, their justifications, or their excuses, or their alibis, or is it incumbent upon the prosecution to disprove them. And the rules of evidence, the rules of courts are going to determine that per jurisdiction. So I know we've mentioned this, perfect and imperfect defenses. Who remembers those terms? Who can tell me just a little, just one thing about perfect and imperfect defenses?
Perfect defenses are like facts. And imperfect are like excuses or just reasons you're giving not facts.
Sure, yeah. I mean, and then the result is what we really focus on, but that's exactly right. So facts could be perfect defenses. So to help remember the difference between perfect and imperfect defenses, we need to just skip all the way to the end. The result of a perfect defense is going to be an acquittal or not guilty.
Or in fact you can prove.
Yeah, something you can prove. So you're going to prove, hey, because there can be facts in an imperfect defense, but the result of a perfect defense is going to be an acquittal or a not guilty. Because your defense was perfect. It has everything you need to show that you 100% did not commit that crime. Either by justification or by facts. However, an imperfect defense is going to result in something less than an acquittal or not guilty. It could result in what's better than guilty, but not as good as not guilty. I'm sorry?
Guilty on a lesser charge.
Guilty on a lesser charge, yeah. So it could be, I did shoot this guy, but I didn't mean to. I meant to shoot near him. I know you're charging me with attempt murder, but here's what was going on. I meant to just scare him. Really, it was assault with a deadly weapon. Imperfect defense. Because I'm not going to be found innocent, right? They're probably still going to find me guilty. So justifications. We've danced around that a little bit today. How do we define a justification? What do we said the term a couple times. Can you help me remember what a justification? Sure. Yeah, exactly. So they admit to committing the act. Maybe we take the word crime out of that because we don't want it to be a crime, right? So they admit to committing the act, but we have a reason why it's not a crime. Does that make sense? All right. Page 144 has 5 elements of a defense, and I want to make sure you know those. Necessity, self-defense, defense of others, defense of home and property, and resisting unlawful arrest. I said 5, but there's 6. Consent is a 6. Pay close attention to those, please. Or make sure you make a note of those. So the first one, necessity. We can't have a justification. Necessity is kind of like the roof that all other justifications live under. whatever it is that you're saying you did, you have to have needed to do it. Whether it's self-defense or consent or whatever else. So in the Trayvon Martin shooting, put yourselves in the mindset of George Zimmerman for a moment. Whatever you know about his defense. So his defense was, I saw what I believed to be a criminal. I tried to stop him. The criminal attacked me, Trayvon Martin, attacked me, and he was beating my butt so bad that I thought I was going to get hurt. In fact, he was slamming my head against the sidewalk or had a little stone on the ground. And I thought I was going to pass out. I had a gun. He would have taken my gun if I had passed out, and he would have hurt me. So what did I do? Before I passed out, I pulled out my gun and I shot Trayvon Martin. That's George Zimmerman's defense. Regardless of how you believe the facts leading up to that, or how much you believe that occurred. That's what he said occurred. So let's put our mind, and let's put ourselves in that mindset. Jake, where's the necessity in that? In his defense. Or we can start, is there a necessity in the way he's portraying it, is there a necessity?
Yeah.
Yes.
Okay, yeah. Can we find it in that story? Well, can we pick out some of the pieces of that story to what I just said when I was speaking for George Zimmerman? What about that story provided necessity?
He said his hand was getting slammed onto the.
So if he hadn't acted, in his mind, if he hadn't acted, he said, I was going to get knocked out, knocked unconscious. The suspect would have taken my gun and would have killed him. Does that, outside of the controversy, merely if you take his words as gospel, does that provide necessity?
Yeah.
Sure, yeah. He is portraying necessity. Now, whose job is it to determine whether or not that necessity really exists? Is it the attorney, the court system, maybe the police officers doing the investigation in a way, but it's the courts, you know? That's a defense. He's saying, you know, I had this necessity to act. Because if he tried to stop Trayvon Martin and Trayvon Martin was resisting, and he pulled out a gun and shot Trayvon Martin twice without the head being slammed on the sidewalk, what's missing? Well, those are the facts. Like I'm saying, if he had just walked up to him and tried to grab Trayvon, and Trayvon jerked away, so he shot him twice. Do we have any necessity there?
No.
No, there's no urgency. And I'm purposely staying clear of self-defense definitions for now. I just want to talk about the necessity, the definition and usage of necessity in justifications. There is no necessity there. There's no urgency. There's nothing that's going to happen. If I don't act right now, then nothing reasonable, right? Because that's the key, reasonableness. In any of these justifications, in any of these defenses, they have to be a reasonable defense. We say that you need to prove a case, the prosecution, not the defense, has to prove a case beyond a reasonable doubt. Not behind any doubt. A reasonable doubt. And the same thing when it comes to defenses. You have to act reasonably. So we've said, I think in week 1 or 2, we said, yeah, I could give you a defense that would show that maybe I didn't do it, but it wouldn't be a reasonable defense. I could say aliens came down and they were the ones that punched, they took over my body and they made me punch you. That's my defense. And if you were a jury, you had to say any doubt, they have to prove their case, the prosecution has to prove their case beyond any doubt at all. Well, the jury might say, well, maybe, I mean, I did see a documentary on the History Channel about aliens. I mean, doesn't seem likely, but maybe aliens came down, you know, he brought it up, maybe it happened. There's a doubt. No, it has to be a reasonable doubt. And then when it comes to defenses and justifications, the person who is giving that justification has to be acting reasonably. So how do we define reasonable? I'll give you a hint. One of the Supreme Court justices said it was very difficult.
That this would happen if any normal person would, have done the same thing.
Yeah, that's a word that's used. Oftentimes people question what is normal, but that is a word that is used in a definition. Would a normal person, an average person, a person with the same knowledge that you have at the time, would they have acted that same way? And that's key. The person that has the same knowledge as you. So let's talk about the officer with Michael Brown. Was he working with a partner or by himself?
Myself.
Right, by himself. So, people that said there's no way he should have even, no way he should have acted, he should have shot. And they don't research the case, because there's a lot of people say he didn't shot that did research the case, shouldn't have shot, and did research the case. They have a lot of knowledge about it. And so I'm not saying that both sides aren't warranted, but if somebody did not research the case at all and said that shooting is completely unjustified, I would have shot him. And that's what they said. There's no way I would have, if I was in that officer's shoes, I would not have shot him. And now you're saying, well, look, this person, a reasonable person says they wouldn't have shot, maybe you shouldn't have shot. But is that a reasonable person who has the same knowledge that officer has?
No, he didn't investigate.
So that's crucial in determining reasonability. Same training, same knowledge. If somebody had never seen a gun before and had no idea the difference between pistols and rifles, and then they saw a video of somebody pulling a gun on somebody else, and that suspect ended up getting shot, and they said that's ridiculous. Why? All they did is just pull something out of his pocket, and the guy got shot for that. Does he have the same knowledge? I know it's extreme, but he has the same knowledge as the person who did the shooting. No, they know that gun is going to hurt them or can hurt them, right? They know that the distances that can occur. They know that it is a dangerous, deadly force situation, and that's why they shot. And the person making that judgment did not have the same knowledge and or training that the other person. So you need to find, when you're judging reasonableness, you need to find somebody with the same experience, same training, and that's what we use in law enforcement when judging shootings. Same training, same reasonableness test.
That's why debriefing is necessary too, as well, too, like debriefing.
I mean, when I was working, we debriefed everything
Every day,
because that's how you learn. That's how you grow as a tactician. You know, learning tactics, admitting mistakes, showing shows maturity, and two, you just learn from other people saying, "Hey, you could have done this better. This is what I did." Search warrants. I mean, I shared with you that we towards the end of my career, I was supervising a unit that just served tons and tons of search warrants, and those are dangerous situations. And you're inserting yourself into somebody else's space, which is a very dangerous thing to do. And you're not sending them a letter, you're not sending them a text like saying, "Hey, tomorrow we're going to do this." It's going to be a surprise. So when we do that, we debrief every single time. Self-defense. If we're going to build a self-defense defense, what are we going to put in there? What kind of elements are we going to put in there? If I'm going to use force against somebody, not even deadly force, if I'm going to use force against somebody, what do they need to be doing to me?
They should be attacking you. They should have a weapon. They should have a weapon or coming at you.
You said attacking or having a weapon. So danger, apparent danger. And we use that term apparent danger because have police officers ever shot a person that was unarmed? And I'm going to use police officers, but self-defense is universal. Police officers don't have a monopoly on self-defense. We just see it more often. So we agree that police officers have shot people that were unarmed. A lot of those shootings are controversial. But are there any shootings of by police officers of a person who's unarmed that were justified? Legally justified? How can we build one? Let's build one of those right now. What could somebody do that would make me justify the shooting them even though they didn't have a weapon?
Made you believe.
They
you
could
have a
reach
weapon?
Made me, how can they make me believe that?
I mean, if they're reaching for something and you don't know, it's not like you have time to find out.
So we'll make an extreme, we stay out of the gray sometimes, right? So if they go behind this podium, reach towards their waistband and tell you, I have a gun in my waistband, I'm fixing to pull it out, and I'm fixing to shoot you right now, when I count to 3. 1, 2, and then, is that reasonable for that officer to believe he's about to get shot?
Yeah.
Is there, what? Did that person have a gun?
No,
Was there any danger?
no,
But it's still justified?
it's justified.
Because of apparent danger. And that's what's key in that definition for self-defense. It has to be apparent danger. You don't have to be right. I sure hope you are. It makes things a lot better for you if you are. But legally, you don't need that danger. You need apparent danger. And reasonable person has to believe that it's an apparent danger. Now, I mean, we could dial that way back, and now we get into the gray. Back behind the podium, no statements, just doing this. Maybe that officer thinks, oh shoot, he's reaching. Maybe not. Maybe a reasonable person would think, well, he didn't say anything. Maybe his belly itched, or I don't know, maybe he's tucking in his shirt. Maybe a reasonable person at that point thinks, it's less reasonable, right? So we need to understand, but then we go back to a person with the same training and the same experience. They would know why. You know, without that experience, maybe a person wouldn't even question it, but the officer was thinking, well, there was no reason for him to go back there and hide his waistband. There's definitely no reason for him to reach. I'd already told him, don't put your hands down. I told him 3 times, don't put your hands down. He still put his hands down. That's a deliberate movement. So now reasonability is coming back in. So here's the thing about that apparent danger. It has to be current apparent danger. I think we've all heard a story like this. Abused wives who shoot their husbands. If a wife is in the middle of just getting her butt handed to her by her husband, just raining down blows, and she feels kind of like the like Zimmerman, like I can feel myself going out. The circle is getting smaller, and then she pulls out a gun and shoots him. Is her life in danger? If she passes out, is her life in danger? Is there an apparent danger? Yeah, and there's a danger, but more important, we don't care. Legally, we really just don't care about the danger. We care about the apparent danger. So there was an apparent danger, and she acted to save herself. We agree? Is that justified? Does she have a legal justification to shoot him? Because that danger is happening right now. What about this? Every Tuesday night is poker night for her husband, Joey Bag of Donuts. Mrs. Bag of Donuts knows every Tuesday when he comes back from poker and he's drunk, he is going to hand her a whooping. Every Tuesday night. It's happened for the last 16 Tuesday nights in a row. And it's Tuesday afternoon, and she's tired of it. She has gotten black eyes, she's gotten a broken nose, a broken jaw, and it's not gonna happen again. So come early Tuesday evening when he says, Mrs. Bag of Donuts, I will see you later. I'm fixing to go play some poker. And when I get back, just be ready for a good whooping. And she says, not today, Joey. She pulls out a gun and shoots him. Zoe, where do we stand? And 16 weeks in a row, he has. Always on Tuesday. Yeah. So is it less reasonable than the first story? Can we agree to that? when she was right in the middle of getting her butt handed. It's less reasonable than that, right? Did she have other options? Valeria, did she have other options? Like what? What could she do when he says, I'm fixing to go play some poker, when I come back, get stretched out because you're getting a good whooping? She could what? Yeah, she could laugh.
His ass would have made it out the door talking that mess to me.
Maybe you were part of the story then. So here's the thing. If you don't have, did she have options when those blows were raining down?
Yeah.
When she was about to pass out? When she was on the floor and she was
No.
about to lose consciousness? Did she have any options?
No.
She was fixing to lose consciousness. However, when he said, I'm gonna go play some poker, I'll be gone for like 3 hours, when I come back, I'm throwing your beat.
She had options.
She had options. She could leave, she could call the police,
She killed him.
she could call mom and dad, she could call his mom and dad, she could call her brother. There's a ton of things she could have done, right? There was no current apparent danger. So without that current apparent danger, do we have a valid justification for self-defense?
I would make one.
No.
He took this as step, he put on his, after he said what he said, and he put on his coat, walked out that door.
You change the story how you want to change the story. My story.
It's your story.
Let's flip the script a little bit.
Yes.
We've also heard this story before. In fact, it was on the news. Father's son gets molested. 6-year-old boy gets molested by the neighbor. Neighbor gets arrested. Neighbor actually gets arrested, and they're transporting him from one state to the other to come back to trial. And as they're transporting and they're walking in handcuffs through the airport, there's a gentleman on one of the payphones. That's how long the story is. There's a payphone. He's on one of the payphones as they walk behind him. And as they're walking behind him, he turns around. It's the father of the 6-year-old, and he shoots the suspect that's in custody and kills him. We're not talking about is it deserved.
No.
We're saying is it justified.
Honest.
Was there an immediate apparent danger, or current apparent danger in that suspect who was in handcuffs in the custody of 2 police officers in an airport away from that 6-year-old who was in another state and he was fixing to get put on an airplane and transported back? Was there a current apparent danger?
No.
I'm not saying that, there's not other factors in there. There could be some mental illness, there could be some PTSD, there could be acting without thinking, things like that. But if we're purely talking about self-defense, you have to have a current apparent danger, otherwise you don't have self-defense.
I'm trying to remember that John Grissom movie where the guy killed the rapist in the courthouse.
I don't remember that, but I've heard a ton of shootings happening in court. Courthouses have a lot of shootings. There's a reason why they don't allow guns.
Mhm.
Police officers are allowed to carry guns in courthouses, but not in federal courthouses. When I testified in federal court, I had to put my gun away to get into the courthouse. So that's what I want you to remember about self-defense. The justification of self-defense is that the danger, one, only has to be apparent. It's a lot better if it's more than apparent. I'm telling you, don't just rely on apparent, but the legal standard is it has to be an apparent danger. You're allowed legally to be wrong. Please don't be. And second, it has to be occurring. If you're doing it preemptively because you think something's going to happen, or you're doing it after the fact to get your just desserts and get your licks in, then those two aren't going to fly when it comes to a legal justification for self-defense.
When you did the husband's wife story, I was thinking about, I thought you was gonna say that he went to bed that night. What happens in that case? You know, because.
Okay. Is
He
there?
went to bed.
So she said if he hands her butt and then goes to bed, passes out drunk or whatever, just goes to bed, goes to sleep. Does she have other options, and is that a current apparent danger? If he's asleep and she's in the living room.
She could justify with the.
There are a lot of ways you could justify it. There's a lot of ways you could spin that story, but if you tell the story the way it is, then it's not a current apparent danger. You have to have a current apparent danger. Otherwise, you have options. You have options for justice, And vigilantism, in general, is frowned upon in our current justice system. And that's what that would be, vigilantism, taking the law into your own hands when you have other options. If there's no other questions, enjoy your day.